Quick heads up. So each presenter will get to
change the lights here.
Yeah, I'll change the presentation setting. How's it going, Bridget? Doing well? Should be on. Ah, there we go.
There we go.
How you doing? We can do that, and then I'll. To get started. Yep. All right, let's go ahead and get started. It's my great privilege to introduce our last full panel for the conference. We made it. And without further ado, I'll turn it over to Gene Kimmelman.
Thank you. You're on now. Okay. Can you hear me now? Okay. Just a reminder, I'm Gene Kimmelman, and I'm the president and CEO of Public Knowledge, an adjunct fellow here at Silicon, and I really appreciate Phil inviting me to participate in my new role. I'm going to let you read about our excellent panelists' bios and not introduce them in full, but I want to just highlight to you that you have former top government officials, leaders in the academy, public interest advocates, people who have been in government and representing some of the most important corporate stakeholders on these policy issues. And we are going to cover the globe and highlight some important domestic aspects of this concept, multi-stakeholderism. And I just want to lay it out before I turn it over to Danny to really dig in, of what is a huge dilemma, I think, for us here, and you're invited to help us try to figure this out. We have an environment that Larry Strickling has laid out before of really almost half the governments in the world deciding that there needs to be greater regulation of the internet. And the U.S. raising a huge red flag to that, as many other countries, about the dangers of interfering with the wonders of the internet and identifying the importance of going beyond government control and multilateral institutions and having a broad set of stakeholders engage openly, transparently, to debate all the important internet policy issues. And many countries in between those two positions trying to figure out what to do. And I think the reason is quite obvious. there are governments out there wondering how they can control the infrastructure that is essential to their society's needs. And for some, it's to control the conversation. For others, it's to create paths for economic, social growth, economic expansion, educational needs, healthcare needs. And they're not going to just walk away from this debate. They're going to look for a place to engage in the policies that they think are critical for their own citizens. And in that discussion, there are a lot of civil society organizations, nonprofits around the world who are very interestingly concerned about their government's interference in essential communications platforms and worried about censorship, but at the same time wanting to see affordable access to the best, fastest communications platforms, hopefully ultimately broadband. They want to see personal protections for their own citizens, privacy and limitations on surveillance. They want to see some form of limitation of discriminatory practices on these platforms, and they worry not just about their governments, but they worry about multinational corporations, particularly those based in this country, that many view as hegemonic and overbearing and just too big for their own comfort. And these organizations are really torn, and they came to a number of events. Danny will talk about the various locales where these things are debated. Last year, truly interested in another path, and everyone talks about it as being the multi-stakeholder path. And now the President of Brazil has called for a major conference to debate these issues in April, suggested it is open, transparent, inviting all to participate, and there is an enormous cacophony of disillusionment about how to do that and how to make it effective and make something called multi-stakeholder really work for these legitimate policy discussions and concerns. And the true danger here is that if we don't find a way to do that, we're back to the countries who like the multilateral discussion and the ones in the middle who want some place to go, and if there's no place else to go, that could be where they end up going. And the U.S. policy that has been so effective in drawing people's attention to the importance of an open internet really may be lost in this inability to fill the void with what is a real meaningful multi-stakeholder process. So that's the environment that we're working in. And I will ask our esteemed panel to comment on their own understandings and experiences of how they think we can accomplish something, whether it is in this broad global space or from domestic experiences that will inform a way forward. So Danny, you want to kick it off?
Okay. Thanks, Gene. Good morning, everyone. Thanks for the wonderful opportunity to be at Silicon Flatirons. Thanks to students who always enliven this community and the staff and all the participants, and Phil for just setting a wonderful tone that's, you know, somewhere between family and really taking these issues seriously as they ought to be. So I want to just try to answer a very simple question in my presentation, which is, what does governance have to do with the internet? I've myself always kind of graded at this designation, internet governance, because it's such a broad term and it's been asked to solve so many problems. So my goal is to try to tease apart a little bit the kinds of governance, the kinds of activities that happen under the rubric now of internet governance. And this is a little bit from the perspective of a participant in a number of these processes, as a government official, and now as a scholar trying to make sense of all the different pieces of this field. I put this picture together really just to illustrate that the extraordinary, what I regard as the extraordinary horizontal nature of the internet as it relates, first of all, to our world, but by extension as it relates to the policy environment. There is no single place where internet governance happens. Just a few examples from here. We have critical governing acts that relate to the internet in venues where governments really dominate. Judiciary, legislative branches have made obviously critical decisions about the internet, and formal international bodies, regulatory agencies. That's kind of on the top of this picture here. On the bottom of this picture is the more bottom-up kind of effort that has shaped the internet in so many ways. Everything from the standards bodies to the administrative bodies like ICANN. I think the social norms and market practices that have developed in the internet have been a critical part of shaping. They certainly represent a number of stakeholders. They don't necessarily meet the definition of multi-stakeholderism, but they represent more individual initiative. And then we have these interesting bodies like the OECD, which has produced an important set of internet policy principles that Karen Kornblue referred to yesterday. And they're, on the one hand, an intergovernmental body, but they've worked very hard to include a number of private sector stakeholders. So I guess if you take away nothing from this presentation but one point, it's that there's no single place that internet governance happens. But as Jean says, I think governments around the world, other institutions that care about the internet, are really searching for a theory about, decision-making theory about a wide variety of internet policy questions. Everything ranging from how should we do technical standards, how should we manage critical resources like the domain names and numbers, and then how should we address public policy questions like privacy, surveillance, cybersecurity, et cetera. What I'd really like to persuade you of is that we need to think about this issue fundamentally in two categories of decision-making and institutional design. The first category, I would say, is defined really by the internet institutions, and that really just represents this one little circle that says technical and administrative standards over here. So the internet institutions are organizations such as the Internet Engineering Task Force, the World Wide Web Consortium, OASIS, and ICANN, these bodies which are fundamentally technically oriented that have come about to make the internet work. They've designed, they've reached agreement about the fundamental design of the internet. They're an ongoing forum by which all the different participants in the internet environment, there's an IETF shirt over there, get together, and really their mission is to make stuff work. That is the single defining success criterion of these bodies. And it's the reason that we take them seriously. It's the reason they have legitimacy is because they have made it work. They've done it from a bottom-up fashion. Anyone can participate in these bodies by some definition of anyone, but certainly they have found ways to include individuals, academics, engineers who work for particular companies, civil society organizations. Emma's organization, CDT, has been a pioneer in participating in the technical standards bodies, bringing that perspective. And governments participate as well, but governments clearly participate as peers. My view of these organizations is that they really represent the ultimate in the aggregation of individual initiative. It may be individual people, it may be individual companies, but these organizations do not exist by virtue of entitlement from the government. They really are the ultimate expression of the kind of individual initiative that leads to innovation, that leads to technological progress. As just kind of a personal confession, I'm a Democrat and a progressive. I believe in government making the world a better place. I don't have a doubt in my mind that that's what government is there to do. But when it comes to these internet institutions, I'm pretty much a classical Scottish kind of liberal. and I think that it's critical as we think about the internet going forward that we recognize that we need to protect the ability for individual initiative to continue to flourish in these environments. That is where innovation will come from, and that is also, I believe, where the openness that we need for democracy and free speech will come from as well. Now, there's been a kind of a funny history between the internet policy process and these internet institutions. From the very beginning in the United States, you know, Ira Magaziner famously declared the private sector must lead. He led to a real embrace of this multi-stakeholder idea, but to be blunt, it was a little bit of a ruse, because from the very beginning of the internet, we had critical legislative activity, critical judicial activity taken by governments around the world, the United States and other governments, that established the necessary conditions for the internet economy and the internet society that we know about to flourish. We got free speech protection for the internet from the U.S. Supreme Court. We got liability limitation for internet platforms that led to, you know, hundreds of billions of dollars of economic activity from an act of the U.S. Congress. We had copyright law that was changed to create a stable environment for, again, for the internet platforms. So none of that was multi-stakeholder. The FTC in the U.S., I think, with a brilliant strategy, established an evolving and dynamic set of privacy norms, certainly in talking with a lot of stakeholders, but it was not a multi-stakeholder process. It was a government-led process. So I think the question is, why do we have this kind of multi-stakeholder craze now, led particularly by the Obama administration? A number of individuals, past and present, are here. I think, and I want to give an example of just a couple of steps that were taken in the spirit of multi-stakeholderism, but with a particular kind of attitude. A lot of people in this room worked on putting together the Consumer Privacy Bill of Rights, which had a twofold function. Larry Strickling referred to it, a twofold function. Number one, it was meant as a legislative blueprint. It was the model that we felt the U.S. Congress ought to enact in answer to Chairman Ramirez's call for federal privacy legislation. But it was also a guide to multi-stakeholder policy-making initiatives that Larry Strickling is now leading, even though he says he's not, at NTIA. And why did we need that? Because I believe very strongly that while the internet institutions have an inherent legitimacy to do their job, to continue the evolution of the internet technology, I think we really ultimately have to look to governments to guide policy-making processes, such as what should we do about privacy. I think that the NTIA is making enormous progress on things like mobile transparency, but I believe that would not be possible without some guidance from the government. I don't think that the right way to think about, well, the way that we should think about multi-stakeholderism as a tool for developing answers to policy questions such as privacy or security or copyright does have to start with some guidance from the government. We're not going to throw a bunch of people into the proverbial room and say, go figure it out, start from scratch. We saw an effort to do that with the do not track process, and it frankly didn't work. And the reason it didn't work is because there were some fundamental normative decisions that had to be made that I think still, in a sort of old-fashioned way, have to be guided by the government.
So, Danny, we're gonna continue this later. I'm gonna make you end with one answer to an important question.
Okay.
Given that, should governments lead the way in Brazil to make proposals that open the door to that multi-stakeholder discussion, or should it happen in a different manner?
So I hope that this framework that I've laid out is a basis on which governments can have clarity about how to use the multi-stakeholder process and how not to use it. I believe that governments ought to recognize the success of the internet institutions, certainly work for greater inclusion in that process, but fundamentally recognize their legitimacy and the fact that they've earned the right to continue to do what they do, that the world should trust them to do it. When we come to what I regard as more, substantive policy questions, whether it's privacy or surveillance or security, I think that governments can use multi-stakeholder processes to elaborate on and implement principles, but I think the principles really have to come from governmental decision making. I don't think there's any way around that in some sense, because the 15 years of history of the internet suggests that the way we've made progress on those issues, such as privacy, is with this delicate interplay of government setting the way, cajoling forward, and then trying to engage stakeholders to implement. So I think it's important to come out of Brazil with clarity about what we can expect of the kind of pure, voluntary, individually led multi-stakeholder processes on the one hand, and where on issues like surveillance or copyright or whatever else it is that governments of the world are concerned about, affordable access, that no one should have the illusion that we can just wave the multi-stakeholder wand over those questions and have an answer.
Okay, so I'm going to hold you on that, and Olivia is going to bring us back to the U.S.
Yes, thank you. Thank you, Gene. It's a real thrill for me to be here. I'm grateful for the invitation from Phil to participate. This is my first time here. I feel like I'm involved in a conversation you all have been having for a long time, although frankly I've been having it with you just from afar, maybe by myself, just looking at the computer screen. I think I'm just going to pick up from where Danny left off and focus in on what is generically called multi-stakeholder governance in the context of communications law. And I will start by identifying what some of the governance norms are. We find them enshrined in the MOU, the ICANN, but you've seen them in the mission statement for IETF and elsewhere. Basically a bottom-up, consensus-driven, multi-stakeholder approach. This has been revised recently to incorporate principles associated with accountability and transparency at the ICANN level. But I want to again, if we look at U.S. Public lawmaking in this space, I think we can also identify and pull out another important norm that is not explicit in those that are in the discussion at international level, and that is a public norm public law norm of deference. And I think deference, as a person who teaches law, and this is the sort of thing or administrative law, is the sort of thing that I think more about than I think many of you, except for maybe Bill over here. And that is that deference operates as a way in which different stakeholders have a different way of contributing to the policymaking process, even as if you accept that governments are the ultimate promulgators of law. So let me unpack this a bit. And then I'm going to go back to a conversation I think many of you may have thought we finished and talking about broadband network management. There are two kinds of deference, right? There's the doctrinal one that you learn when you go to law school about Chevron and Skidmore. And that's not the kind of deference that I'm going to talk about. So this is the kind of deference that courts give to agencies because there's an ambiguous statute and Congress has delegated the agency with the responsibility of making sense of an ambiguous statute in a complicated area. That functions as law in U.S. public lawmaking. I should say judicial interpretation of agency action. The second conception of deference is more general, and it takes and adopts a more institutional view. And that is the kind of deference you see between courts and agencies, but also between agencies and self-regulatory organizations or agencies and standard-setting organizations. Also, you can also think of this as the kind of deference courts give to legislatures, and I'll talk more about that in a second. As to the second category, there are two underpinning ideas, and I think this helps us think about governance in a technologically dynamic area like this one. The first is expertise. Danny was alluding to this and the good work that IETF and others have done before the commercialization of the internet in the 1990s in developing the protocols associated with the internet. So there's a kind of expertise, and with that expertise, agencies, governments defer. And I'm going to talk a bit about how that has worked in the context of broadband network management. So that's one category, right? So there's kind of legitimacy obtained over the course of time because of the good work, the good expertise born from the capacity of the institution to collect information, to engage in consensus building conversations, but also in the sheer knowledge and wisdom associated with the subject matter that agencies and governments don't have. The second is something that's born from a prior commitment that's evocative of constitutional principles, and that is democratic legitimacy. And that is something that I'm not sure, notwithstanding how wonderful the consensus-building process that self-regulatory organizations are involved in, can make the same claim to. Indeed, there are a whole set of cases in the administrative law setting in which courts make a distinction between the deference that we give because of expertise and the deference we give because an institution is a superior and has more democratic legitimacy. And this is part of the doctrine. And Chevron itself, the case that kind of articulates the view about how when courts defer, talks about the fact that judges, for example, have no constituency. We might say the same about agencies. We might say the same about non-governmental entities. They don't have the same constituency in the same way that the FCC or even better Congress do. So I'll come back to that in a moment. So this takes me to the discussion about broadband network management. So Danny very helpfully, I think, talked about the ways in which the U.S. government put its imprimatur on what it means to have an internet freedom, right? So we have the CDA, Section 230, which immunizes intermediaries for torts when they're just acting as passive conduits, right? Congress decides to do that, include that. Of course, you have the Supreme Court's decision, ACLU v. Reno, about First Amendment. But it's not just that. It's a crisper articulation of how this deference worked back then. A deference to self-regulatory organizations is the NTIA's delegation to ICANN, right? And the assumption that ICANN would be a good administrator of the DNS and IANA function. And better, we can also talk about the FCC's regulatory light touch during this early period. These were the components of what I think people thought of as internet freedom. But to be clear, these were components that were at the early period of this medium. Things have changed, right? We've talked about how it's become contested. Indeed, this is a contested space and no longer the sort of thing that we relegate to the boutique sophistication of engineering solely as engineering. Surely that's an important feature of what we do. But transmission standards are now, in the last mile at least, contested. And we have a tool for resolving these things, and that's a public law process. We had a nice discussion yesterday about the IP transition order. I think the Open Internet order also helped to illustrate ways in which governance in this space, at least as it comes from the FCC, has changed over time. So from the Advanced Services Order in 1998 to Brandex's decision in 2005, I might frame one period, and we have something that follows. 2005, contested period, promulgation of Internet Policy Statement. We have a litigation associated with Comcast's throttling of content. DC Circuit rejects it. Then we have the Open Internet Order, and very interestingly, the DC Circuit case, which wasn't discussed as much yesterday, this component of the case, Judge Tatel, in his opinion, says the FCC has jurisdiction here under Section 706 to regulate network management. They have exceeded their statutory obligations because they do something that looks more like common carriage regulation, but we have authority to do that. That is a transition, and that's the transition I want to underscore, that this is a process that has gone from a deferential one that looks to non-governmental entities, right, ICANN, IETF, to one in which this has become part and parcel of what it means to regulate in the way that we regulate most other industries. This is also my loose invocation of this notion of deference. Deference is a kind of idea that can be changed upon circumstances. You defer to agencies under certain circumstances and not others, and we can talk about this across substantive areas. I think I'll stop there, although I will say one more thing. This also came up yesterday in the discussion of the IP transition, and that is the identification by public lawmaking bodies like the FCC about public values that are not, first of all, that are not explicit in substantive design norms that IETF and other entities promulgate, namely public safety and universal access. We can also add consumer protection and competition to that. But it's also not within the competence of those non-governmental entities to engage in that sort of public value norm promulgation. So that's all I'll say.
So, Bill, what jumps out to me as I hand over to you is the complexity of the development of competition law globally, and the fact that it has some interesting parallel attributes here. Some very technical questions about economics, consumer welfare. How do you measure it? Are there tools that are generally accepted, especially in a global economy with companies traversing many borders and transactions engaging across border? And then a distinct body of law that's quite complex and has developed over time.
Only the smartest people can master it.
Well, there's some who say that. And then there are a lot of countries that are just engaging and saying, maybe we need to look at a body of law like this. So can you reflect from the antitrust perspective and more broadly how that has developed and what light it might shed on this discussion?
Thank you, Gene, and thanks to Phil and to Paul for the wonderful opportunity to be here. At a recent international conference, I heard an American official say, to conclude his talk, that the path ahead would reside in multi-stakeholder governance. A hand goes up from a foreign official who says, sounds like a cliche, what does it mean? That is a powerfully good question. What exactly do we mean by that? And I think Danny has started us off in a very helpful way by underscoring what I think to be true, which is ultimately for the establishment of binding principles or formative guidance. That ultimately is a public agency function over time. But I want to talk about what I do think to be the valuable role of participation in forming the consensus and how that's done. Why should public agencies consult broadly with the outside world in formulating principles that might be applied? Olivier touched upon each of these. First, to build knowledge about what the standard should be. Second, to establish a consensus as well as it can be done about best approaches. And last, as he underscored, legitimacy. That is the sense that a broader consultation is more desirable for the same reason that the Administrative Procedure Act mandates certain forms of consultation as a predicate for rulemaking. I want to talk about this in three parts. First is to underscore beneath the statement of multi-stakeholder governance why it's so hard to do, especially in the suggestion that you can talk to everybody, let everyone participate, everybody gets a voice, and we all agree. But why the role of the FTC, second, as a convener that facilitates the process of forming consensus is important, and why the FTC has provided a very suitable platform for participating in resolving the issues that Gene mentioned, and to give you a specific technical illustration that shows how that's played out internationally. Why is the process of consultation difficult? First, for individual disciplines, policy fragmentation within a single jurisdiction is extraordinary. If you ask, who makes privacy policy and applies it in the United States? As Edith just said, well, it's the FTC, but it's the Federal Communications Commission, it's the Department of Commerce, it's Health and Human Services, it's the Department of Justice, and oh yes, our friends the states. You can make a pretty good argument that the state of California deserves a place side by side with the national government institutions in international discussions about privacy because its influence is so powerful. Second, there's a huge interdisciplinary dimension that means that within a single area of policymaking, individual agencies find it necessary to cross borders. If you're going to talk about the IP competition interface, you must be involved, for example, with the Patent and Trademark Office. So it's not just the fragmentation within one discipline, you're crossing property boundaries to deal with others. Third, we've talked about the increasing cross-border spillovers that are so obvious in this field, decisions by individual jurisdictions, linked to effects in other jurisdictions. There's a huge amount of interdependency, and many jurisdictions, because they are powerful enough, have the ability through their unilateral steps to impose, in effect, broad-based standards. Now, to a certain extent, as Edith mentioned, there's a bit of ignorance out there, but there's something else going on. there's a real contest for who sets the standards. There are rival standard-setting agencies. I discovered in the mid part of the previous decade going to give talks in Europe where they would begin by saying, now we will hear for the Anglo-Saxon representative. That's an epithet, by the way, on the continent, about the ridiculous privacy regime in the US. So the Anglo-Saxon delegate. By the way, there's another hyphenated vulgar expression that is the translation of that. The Anglo-Saxon delegate gives the talk. I had a slide that said, here's the statutory framework, looked a bit like that. And here are the top 10 cases in the last 5 years with the recoveries. Have you guys got anything like that? Of course not. I thought, fine, the point's across. Next year, same criticism, same slide. What I discovered is that they want to believe that. That is, especially in Europe, there is a sense of wanting that standard to prevail. So it is not just a matter of not knowing enough about the U.S. regime. They know quite well, in the way that a taxi driver in Paris, as you try to speak, your best friend says, "Oh, monsieur, I do not understand." Understands quite well, but is not going to converse with you in French. In this instance, they know what the U.S. framework is, but there is a desire to have the European standard applied broadly. Another circumstance that makes it difficult is we talk about civil society, extraordinary fragmentation. If we just look in the privacy domain, if we look at advocacy groups that have had a role to play in this, a very diverse array of views about how stringent in what areas privacy policy should be developed over time, it's extraordinarily difficult to get a comprehensive and persuasive consensus. You're often driven down to lowest common denominator solutions if you want to rely on that process to generate a universal view about what ought to be done. And the last condition is dynamism. Why does that matter? Why is technological dynamism important? First, it blurs all of these jurisdictional boundaries with respect to disciplines. That means that more public agencies on any single issues will claim to play. They'll say, we're tenants in common, we're in this domain, and you don't oust us through your individual decisions. And second, as much as agencies like to say, yes, yes, we're bright, we're expert, they are, the fact of rapid technological change puts extreme pressure on the joints of agencies that depend upon a deep knowledge base to make a good diagnosis, much less to come up with good solutions. Why is the FTC an interesting example? The 1914 design made it a scalable, adaptable convener to perform a consultative function and to assist in promoting consensus. And there was an early recognition through the FTC's work decade by decade that it had to rely on contributions from what Alan Fels has called co-producers, academics, business groups, advocacy groups, professional groups around the country to assist in forming the base of knowledge and implementing policy over time. In the area of privacy, for example, the FTC over time has performed the convening role quite a bit. I just sharpen a little bit Danny's characterization of the development of privacy. I agree that ultimately the privacy commands have come out of public institutions, but there was a massive period of consultation that the FTC used through a variety of devices to inform what those views would be, to make them more legitimate and effective. Many of you participated in that process. So the stakeholder consultation was intense and expansive. Let me finish with an example that shows both the promises of the broader consultative process, but its pitfalls. And this is, in the area of competition law, how do you form a sense of international consensus about norms? Norms in academic speak are not binding rules. They are ideas about how people should behave, but they often, when they are widely adopted, provide precursors for what become binding rules. When people opt into norms, it's a form of dating, in effect. If they become comfortable with the norm and standard, it's a short step to saying, let's impose it as a mandatory requirement. There were pre-existing networks for competition law where we've gone from 20 jurisdictions in 1990 to about 125 today. That is a staggering growth in a period of barely 20 years. One was the OECD. They were there. What was the problem? Too rich, too small. Largely rich countries. They made efforts to bring in others as observers, but this was seen as the rich person's club and all government-to-government relationships. What does that mean? If you go to the OECD meetings, you attend as a representative of the government of the United States, and you have an officer from the embassy or the mission who sits in the room with you, which means that a competition meeting, if you're asked, does trade policy impede the accomplishment of competition goals? And you say, it certainly does. It's one of the cartel's best friends because it facilitates cartelization, it impedes entry, and if I had my way, I'd strip away lots of the restrictions on trade. You are given a cold cup of coffee by the embassy, your green passport is taken, and you are sent home. So you do not have the freedom to engage in the open give and take that might take place otherwise. The notion was a different organization ought to be established, and the OECD had a very ungenerous role for non-government organizations. They were allowed in the room for a bit, but there was a ceremony when the discussion was closed in which they were asked to leave the room. And there was a walk of shame through which, before all present, they would proceed out to the door, to the great glee of the government participants who were happy to see them leave. In 2001, as a result of a DOJ white paper prepared as a result of a public consultation, a new institution's formed called the International Competition Network. What are its characteristics? Not government to government, it's agency to agency. Freer discussion among the government bodies. Second, wide role for non-government organizations, academics, consumer groups, and for the private bar. Very touchy issues about how balanced and broad the representation is, but an effort to bring them in. Widespread participation in the development of norms through working groups, the preparation of recommendations, and continued engagement over time. You do have, though, with the large group, the one-room schoolhouse problem, which is how do you teach first-year French and 12th-year French in the same room when you have everyone present, who speaks, how long. The notion that everybody gets to talk, everybody gets to vote, everybody gets to decide, and we don't do anything until we have a universal consensus is precisely a formula for going nowhere. A couple of lessons from this process. If government agencies want to play this role effectively, that's a huge investment. And it's an investment in non-litigation resources. How do agencies get scored? How many cases, how many rules? Not how well you built the infrastructure. But you can't do this on the cheap. If you want to play the convening and consensus building role, you have to spend real resources. The 2003 report that Edith Ramirez referred to on IP to promote innovation, that was 25 days of DOJ FTC hearings. We had 5 of our best people working full-time 3 years on that project. That's a really expensive investment in this consensus building process. You probably have to participate second in multiple fora in order to gain a sufficiently broad set of views and to engage in a debate over individual matters. You have to distill the results into reports that are both positive and prescriptive. This is Carl Llewellyn doing the restatement on contracts. Yes, it was a faithful statement of where contract law was, but it was prescriptive, and Llewellyn and his co-authors consciously sought to move the boundaries outward in a prescriptive way. And last, you have to stay at it. This doesn't get done in the short term. You have to be willing to do it this year, next year, and the year after that. That's the only way that your counterparts on the outside know that you really mean to play this role effectively.
Thanks, Bill. It's very provocative, as usual. John, your own thoughts, observations based on your experiences with these issues.
I am John Nectarline. I am the General Counsel of the FTC, so I have to begin with the disclaimer, which is that I'm here speaking only for myself and not for the Federal Trade Commission. Although I think I can speak on behalf of the Federal Trade Commission in thanking Phil and Paul for putting together such a terrific conference, as always. I'm going to key off of a couple today about a dichotomy that you read about a lot between multi-stakeholder processes on the one hand and government top-down mandates on the other. And I'm going to suggest, and I think some of our panelists have alluded to this, that this is not a binary choice. There are hybrid forms of government multi-stakeholder interactions that produce optimal outcomes. And in particular, things that sometimes look like top-down government mandates are really government-enforced multi-stakeholder agreements. They are similar to settlement agreements that lawyers enter into that are then followed by a consent judgment by a court. I'm going to focus almost exclusively on the domestic side of this, and I'm going to use the FCC as a case study. Bill spoke of the FTC as a convener. I'm going to speak of the FCC as a convener. There are a couple of areas where the FCC has played this role particularly well. One is in the context of intercarrier compensation reform. In that area, there have been a number of occasions over the years when the FCC has said to the industry, look, we have a problem. It's extremely complicated. We are going to look to you to come up with a solution that has credibility and that we can then bless. One obvious example of this that comes to mind is the calls order that the Commission issued in 2000. It is one of the proudest accomplishments of Bill Kennard's tenure as chairman and of Larry Strickland's tenure as Common Carrier Bureau Chief. The intercarrier compensation reform continued through the 2000s. These were processes in which everyone understood that the money that one carrier paid to another wasn't truly cost-based. And over the ensuing decade, the FCC kept saying to the industry, get together and work something out and come back to us with a credible proposal. There were many efforts to that end. In 2004, there was the Intercarrier Compensation Forum proposal. In 2005, there was something called the Missoula Plan. And finally, in 2010, there was something called the ABC Plan. Ultimately, in 2011, the FCC, in broad strokes, accepted the ABC Plan while making some important modifications. This, though, is another example of the FCC bringing all relevant stakeholders onto the table to talk about what was an optimal outcome for the group as a whole. There were no clear winners in this process. There were few losers. Many people who observed this viewed the collective outcome as sort of a Benthamite result where the collective utility of the stakeholders, including consumers, was maximized. The other example I want to give of this, where things that look like government mandates are in fact government-enforced multi-stakeholder agreements, is the Open Internet Order that we talked a lot about yesterday. The genesis of that order came in next door in the old Colorado Law School building when Michael Powell stood up in 2004, almost exactly 10 years ago, to announce 4 principles of internet openness. Those 4 principles he didn't retrieve those from Mount Sinai. Those 4 principles reflected a deep industry consensus about what was an appropriate form of governance of the last mile. And he didn't make them into rules, but he did what people call classic jawboning, which is essentially, don't make me codify these, but here's what I understand your norms to be, and please go follow them and continue the conversation about what these norms should be. In many ways, you can see the same process of the FCC as convener occurring in the discussions about the Open Internet Order between 2009, when the FCC first issued its NPRM, and 2010, when the FCC established rules. The 2009 NPRM was very broad and reflected on some issues some degree of technological naivete. What happened in the intervening year is that there was a massive multi-stakeholder effort where all parties that were interested, this includes ISPs, it includes content providers, it also includes public interest groups, the 2 most important of which are represented at this table, CDT and Public Knowledge. And the result of it was an outcome that reflected consensus in that multi-stakeholder process. It didn't please everyone, but it did, however, reflect industry norms. And I am willing to submit that there are few, if any, business plans that have been seriously affected by the Open Internet Order. And for that reason, I am optimistic that the DC Circuit's invalidation of major portions of that order will not actually affect broadband behavior, in part because the order was already a codification of existing norms to begin with. Now, some people look at these developments in a pejorative light. They view them as a form of industry capture, regulatory capture. They ask why the FCC can't just figure out what the right answer is and then impose it in the public interest. And the answer is that in many contexts, particularly very complex technological contexts where the underlying economics are changing rapidly, multi-stakeholder processes are more effective in producing optimal outcomes. But at the same time, there are also some contexts where those multi-stakeholder processes wouldn't take place at all if the government didn't step in to say, we're going to impose enforceable rules. You guys figure out what those rules should be, and then we're going to codify them. The FCC, in this context, the FCC's role was valuable for two reasons. Or three reasons. It brought everyone to the table. B, it forced everyone who was at the table to think in enlightened terms about what sorts of regimes would be credible as a governance structure. And third, it reinforced the norms that the multi-stakeholder community itself had come up with and established an enforcement mechanism for them. So I'm just going to conclude by saying that this is not a panacea. This is not to say that the outcomes of multi-stakeholder processes are perfect, that they always serve consumers as best as they could, and that's the ultimate inquiry. But it is often better than the alternative, which is either no government-led process at all, or instead government top-down mandates. And in the international context, I think we're seeing something similar. Danny said something that I thought was very instructive, which is that the reason that today's internet multi-stakeholder governance bodies have legitimacy is that they've made it work. And the same is true of the process that I've described. When the FCC or the FTC brings parties together in its role as a convener, the role of the multi-stakeholder body will be more or less effective depending on whether they collectively, in their enlightened self-interest, come up with a policy solution that is agreed to promote the public interest.
Thanks, John. So Kyle, from your high-level government experience and now private sector, does this ring true, or do you go a different path?
I actually share a lot of what's been said, but first I want to thank Phil and Silicon Flatirons for the opportunity to speak with you today. It's a great opportunity for to step back and sort of put our advocacy hats aside and talk about what some complex issues with some nuance. So in thinking about how to tie the different presentations together and comment on them, I found myself thinking about three interrelated questions: comparative institutional analysis and multi-stakeholders. And a lot of these questions have already been teed up and I think answered pretty well by some of the presenters. First, what other institutions are we comparing multi-stakeholder processes to, including those that are already operator? I think Danny's presentation is especially helpful on this point with respect to the context of internet governance. That is, the internet is strongly influenced by a number of organizations beyond ICANN: technical design distinctions or decisions, corporate policies, private commercial negotiations, et cetera. So I'm very much in agreement there. Second, I think we need to think about what functions we're asking multi-stakeholder processes to perform. Laura DeNardis at American University has laid out what she calls a disaggregated taxonomy of these different functions in the context of internet governance, which I thought was very instructive in my research. And she talks about functions ranging from control of critical internet resources to coordination of access and interconnection, like peering or CDN arrangements, privacy and cybersecurity regulation. So I agree that sort of relying on multi-stakeholder processes as a sort of panacea is probably not the right idea, and we should all be thinking about sort of specific functions and whether multi-stakeholder processes are well suited to perform those functions. I also think we should do what I think the presenters did pretty well, which is to go beyond the sort of familiar stated dichotomy between technical issues on the one hand and policy issues on the other, which I think at best denotes a sort of increasingly blurry distinction. Olivier's presentation, I think, helpfully touches on this, where he argues, at least in the paper that we saw ahead of time, that we can no longer rely on technologists alone to govern the internet. I think that's true in part because the internet has grown in both societal and economic importance, and it's hard to manage this critical, fragile resource without straying into policy issues. I think the question is whether multi-stakeholder processes are better at handling these policy issues than other institutions that, as I've mentioned, may already be operating. My own view is, I think that consistent with some of the other speakers today, is that even as we strive to maintain an important role for multi-stakeholder processes, we should recognize at the same time that there may be benefits to preserving a role for other institutions like public law and government in some cases. Perhaps this is where Olivier's point about thinking about where and when we should be deferring to government could be useful as a line of research to further develop. And then finally, my third question is the sort of how we assess the performance of multi-stakeholder processes. And here there are a lot of sort of structural and procedural guideposts in the sense that Olivier mentions, and also that Phil and Joe Waz mentioned in their 2012 paper. Things like engagement at a high level by a diversity of interests, openness, accountability, et cetera. And I also think that Bill's talk supports the view that government can contribute to a successful multi-stakeholder process by serving as convener, at least in some cases. Indeed, I think relying on government as a convener can be especially useful in some of the cases that I think Danny talks about in terms of developing consensus around policy. So, for example, my observations of the NTIA's process on developing a code for mobile app transparency, my impression was that they were very successful, even as neutral facilitator, in nudging participants with very, very different, highly strongly held views to be more honest, more civil, and more willing to cooperate than they would have been otherwise. And as Bill touched on as well, a government convener may at times be helpful in ensuring that multi-stakeholder discussions are grounded in current law, as well as relevant disciplines such as economics. Again, I'm not suggesting that should be done in all circumstances, but I think government can serve a useful convening role, and we have to look at specific instances. But beyond those sort of structural and procedural traits, I think it gets very sticky exactly what constitutes success. I think it's very much in the eyes of the beholder. We got into some of this in the panel yesterday on the social contract. In terms of internet governance, I think from my perspective, one vision would be one in which we maintain the internet as an important driver of economic growth by preserving strong incentives for all participants in the ecosystem to continue investing and innovating and otherwise throwing value at consumers. More content, more applications, more devices, more in all dimensions. And I don't know that we have a lot of disagreement about that. And then in closing, I think I would just say that sort of the kernel of this sort of pro-consumer vision that I laid out has already been sort of enshrined in things like the OECD internet policymaking principles that Karen Kornblue mentioned grew out of some of the hard work of some of the people here. And I tend to agree with Danny that having clear principles like in the OECD guidelines can be very useful in grounding multi-stakeholder discussions, but exactly how that plays out in specific contexts, I think, is going to require a lot more conversations like this and a lot more research. Thanks.
Great. Thanks, Kyle. So, Donna, you've been focused like a laser on domestic policy and strategic alliances. So how do strategic alliances and policy fit together in this conversation?
Yeah. First, let me thank Phil and Silicon Flatirons for inviting me to participate. This is actually my second conference, but first-time participant, so thank you very much for this opportunity. Let me just start off by saying that I think, like others on the panel, that I certainly believe that maintaining and strengthening the multi-stakeholder model, both domestically and in the international context, is critical to ensure continued growth and innovation on the internet. I do focus primarily on the domestic policy issues, so let me turn our attention to that. Domestically, I really think that we can and should leverage the multi-stakeholder model to address even more emerging internet policy issues. This is a timely discussion as the House Energy and Commerce Committee begins examining how best to update the Telecom Act. And so a lot of us are thinking about what does a 21st century policy framework that is pro-consumer and pro-innovation look like? I believe that that framework should rely in part on an approach that includes effective multi-stakeholder processes for decision-making and policy solving, either formally or informally. If used properly, these mechanisms can serve as a vital tool for modern-day policymaking. The issues we're facing now, as others have noted, are more complex than ever. They often don't lend themselves to simple answers. They're multifaceted. They require more nuanced approaches than they did in the past. And to the point of strategic alliances, I think in particular, the FCC has done a great job of reaching out to all of the various interested parties that have a concern and interest in ensuring that these policy issues are dealt with properly. So I think given sort of the multifaceted nature of the problem and the stakeholders, that the multi-stakeholder process is particularly well suited to deal with some of the challenges that we face. Certainly none of us can predict where innovation will be going next. And I think all of us agree that we need to be careful about sort of blanket ex-ante rules that could have at least the potential to stifle investment in innovation. As circumstances change on the ground, and they do change quite rapidly, as we all know, with technological changes, changes in business models, the multi-stakeholder mechanism can adapt more quickly than traditional regulatory activity, and they can oftentimes provide more customized solutions to fit the unique context of a particular problem. This, of course, creates efficiencies for consumers as well as for the marketplace. And given that, I think oftentimes in the first instance, we ought to look to multi-stakeholder processes. Now, let me just also, like John, highlight an area where, and I do think oftentimes these processes are most effective when you have a hybrid form, and I think we've seen a hybrid form of government and multi-stakeholder processes. I also want to just expound a little bit on a process that I was directly involved in at the FCC, and this is one that doesn't get a lot of attention, but it was hugely successful, and it involved the FCC's Measuring Broadband Performance program. There, for those of you who are not familiar with it, there was concern that ISPs were advertising performance that exceeded what they actually were delivering. And so there was a very clear objective up front, to your point, Danny, of laying out very clear objectives and principles as to what this process should accomplish. Very clear objective was, how do you develop a testing methodology that would accurately reflect the performance of very different wireline broadband platforms, the cable as well as the telco platform. This was an intersection of policy as well as technical issues, because as you might imagine, coming up with a testing methodology that would yield apple-to-apples type data and that would accurately reflect the performance of these networks is no small feat, and it hadn't been done before. There were various apps, speed tests, et cetera, but nothing that had captured a comparative performance of these different networks. The process for coming up with the solution was laid out in the National Broadband Plan. And before the FCC actually sort of served as a convener, members in the ecosystem were already getting together from industry, civil society, consumer groups. But the FCC came in and sort of co-opted the process, and I think added quite a lot of value, not by substituting their judgment for how to develop this. In fact, it really required a lot of technical expertise from the various companies to explain the idiosyncrasies of the various technologies and the networks and how they operated. But the FCC served a real a role in terms of helping us to find areas of compromise, helping to find areas of consensus, and really serving as a sounding board to guide us to an outcome that I think everyone that participated in that process would agree was far more thoughtful and accurate than if the FCC on its own had developed the testing methodology and sort of mandated and imposed it. And so I think that given that we have a number of good models to build on domestically, that we have a strong foundation to build on that. And actually, we should be looking towards lessons learned on the domestic front to give guidance, what works, what doesn't, in the international context, to the extent that we can export some of our learnings to strengthen the international multi-stakeholder processes. I think we can continue our leadership in this area.
Thanks, Donna. So, Emma, you, does this translate from domestic to global? You're a veteran of the ITU fight at the Wicket. You've been engaged in the Internet Governance Forum discussions, fully engaged now in the preparations for Brazil, a number of the UN committees considering these issues, and the WSIS plus 10 process going forward. Bring us back to the scenario leading up to Brazil and whether these kinds of examples and past practices can really help inform that process.
And all the students for putting on such an interesting and lively conference. And I really want to underscore the importance of, we've had about an hour of really interesting discussion here. And it is so important that we have these kinds of conversations with people outside of the United States. I think it was Bill who mentioned hearing someone refer to multi-stakeholder governance as a cliche. It is very easy to have it be just this multisyllabic phrase that gets bandied about and is, to be frank, met with a lot of skepticism from people outside the US when they hear US stakeholders, whether it's governments, industry, or civil society, making a sort of generic embrace of multi-stakeholder governance. That doesn't mean a whole lot, and particularly after in the environment of the NSA surveillance revelations, it's really met with a lot of raised eyebrows and concerns about what might be lurking behind this phrase. So I think if we can take this kind of conversation and have the depth and the range and the kinds of topics we've had and really focus on having this rich of an exchange and dialogue with all of the other stakeholders around the world who are focused on these issues, that's where I think we really need to go with this. We've been talking a lot about the role of governments on this panel, and that's the question that's motivating all of these debates, the number of different processes that Jean just mentioned, the World Conference on International Telecommunications, the ITU's Big Treaty Conference that took up a lot of the oxygen in 2012 and had the outcome in December of sort of a split between who signed the treaty and who didn't. That fed into the World Telecommunications Policy Forum in Geneva this past year, where most of the discussion was devoted to a single proposal from Brazil about the role of governments in all of this. There are working groups on enhanced cooperation looking at this. There's the upcoming World Summit on the Information Society. This is the conversation that governments around the world and all of the other stakeholders really want to have. And so I think if we can take the kinds of insights that we've had on this panel, looking at the acknowledgement that there are certain roles and responsibilities that are appropriately, the decisions of governments, and acknowledging the specific roles that governments, of course, do have, and also looking at, I think all of the panelists touched on this, the role of government in creating the environment for multi-stakeholder processes. Multi-stakeholderism doesn't just come out of nowhere. Government has a role in establishing fundamental protections for freedom of expression. You can't really have a robust exchange of views and ideas if some of the participants in the conversation are worried about getting thrown in jail because they're criticizing suggestions by the government. looking at the role of government in deciding when and how to defer to expert agencies or other institutions, talking about the role of government as a convener. I think it's clear that, especially for those of us in this room, each of whom would probably recognize the inherent stakeholderness of everyone else, we've got a comfort level with this kind of exchange and this kind of discussion that just doesn't exist in most of the countries that we end up discussing these issues with at intergovernmental organizations. And so I guess I just emphasize that I think one of the real opportunities for trying to shift the conversation at the international level is not to just focus on our own processes and not to just look at where are these debates happening internationally, but to look at the national level opportunities for multi-stakeholder and participatory processes in different countries. What are the opportunities to support existing processes like that? What are the opportunities to host convenings where you try to bring together the different stakeholders and give them that first step of, or help them, establish and build those trust relationships, figuring out ways to work toward establishing the kind of comfort level that we all have here in the U.S. with these kinds of discussions, I think will go a long way into encouraging, or at least making this concept of multi-stakeholderism easier for people to grapple with when it comes up internationally.
So Emma, I'm going to push you a little bit here. Does this happen in Brazil, or is it just another meeting?
Do you mean, does this happen at the summit? I think there's probably a better chance for it happening at the Brazil summit, in part because Brazil does have its own domestic experience with this kind of multi-stakeholder process. They have the Brazilian Internet Steering Committee, which is intentionally composed of civil society and industry and government representatives that have been working for years on developing the Internet Bill of Rights in Brazil, the Marco Civil. And so I think we have there in the host country already a kind of an understanding and familiarity with the multi-stakeholder process that, and I think we see it in the committees and processes. There are many of them that are sort of feeding into creating this meeting and establishing the agenda, that there has been a big focus on making sure that there is representation from all the stakeholder groups and that there are self-nomination processes for the stakeholder groups. So it's not just government officials identifying which people from civil society they will invite to serve on a committee, but really turning to the different groups to self-identify who do they want to have to represent them on these groups.
So I'm going to draw everyone else back into the conversation on that point. So interestingly enough, as we've discussed all the things we've done here, you're indicating that Brazil has really done something very similar as they prepared their Marco Civil and their copyright law update as well. However, Bill gave us a big challenge. You have to have the relevant agencies, and this isn't just communications regulators. They go to the ITU. This is the foreign ministries. This is whoever oversees intellectual property law in these countries. This is massive. It's not quite as narrow as antitrust regulation in these countries, so it's a bigger problem. And then the difficulty is many of the companies who have expertise have the resources to present their experts across each of these areas. The governments bring their people. The technical community, as Danny's identified, has expertise across a variety of these issues. And then there's civil society. And I think from the nature of the conversation, everyone's indicated the domestic experiences. It's wonderful when you have everyone at the table working together and looking for consensus. You put it into a global context, in a global meeting, who from civil society should be there? Some of the biggest groups reject the OECD process and the Internet policy principles for the very reason Bill said. It's a narrow club of rich countries, and they weren't invited. So how do we do this? There's a level of, you talked about resources. and long-term commitment, there's a level of expertise that is needed across many countries to be able to do what John and Donna and Kyle all described as very successful here. How do we do that? Or can we do that? Danny.
I just want to point out, first of all, I'll say I took everything that Bill and Olivier and John said about what I took to be a kind of more of a spectrum of multi-stakeholder activity, including governments really engaging in order to get to a good result, led by governments. I think that's I think that's part of this whole picture. But I think there is still a discontinuity here in the difference between what we see in the internet institutions, the standards bodies and the administrative bodies, and everything else that we're talking about. And the discontinuity is that, Gene, it's really, I think, on this question of representation and mission. You ask the question of who should be, quote, represented at, for example, a World Wide Web Consortium or Internet Engineering Task Force Working Group is not a particularly coherent question, because the answer is anyone who's building the stuff should be there, and then anyone who has something to say about it can be there too. But actually, who will matter in the ultimate outcome is who builds the stuff. Now, that's very different than the outcome that we expect in a policy process where, in fact, we care about more than just who's operating the networks or more than just who's assigning the domain names. We care about the interests of the users and consumers and citizens. And I think this is really why it's very important that we have some direction from governments, obviously informed by all the other stakeholders, as Bill suggests. But I think I don't know how to answer the question of representation because we know how to answer that in a democratic process. I would submit that the internet institutions are, by design, not democratic. They don't get their legitimacy from the consent of the governed. They just don't. And we're now trying to create this kind of hybrid where I guess I think that if there either is or isn't legitimacy to what comes out of a discussion in Brazil, I do think that some part of it will have to come from governments. Just will.
Bill, you want to jump in?
Yeah, I think at some point what we might call private or non-government activity is blessed by the government, is incorporated by reference by the government. At some point it assumes a public character.
Can I actually say, I think it's actually the opposite. I really think it's important that in the internet environment, it's been exactly the opposite. It's that we've had all this stuff that we have, all these networks, the web, everything else that we have because of private initiative. Government, and that's the opposite of the way that the telecom world works. And I still, in this room, still feel very much a little bit sort of odd person out.
I'm suggesting, Danny, that at some point, the private activity, to the extent that you have privately developed norms,
yes,
at some point governments say, I like that norm. And either we will rely on it implicitly as an expression of public policy, or we will forego public intervention because it exists and works well. I'm just suggesting, to the extent that it becomes a pillar, either explicit or implicit, for public policy, it's at that point that you get the demands for the participation, where especially in the international environment, where you have less wealthy jurisdictions starting to say, who did that? And I think Gene's right. In that setting, there is the baggage that the United States carries, that the Europeans carry, is that to many emerging market economies, the big international organizations, UN, WTO, OECD, even the ICN, it's just another forum in which the powerful jurisdictions trample the interests of the dispossessed. That's a caricature, But it's why, for example, many UN proceedings are extremely popular because they are perceived to be less captured by the other organizations. I think on Gene's question, I think in many instances, look at the extent to which the Western countries, well-developed market economies, rely on academia to be a proxy for broader public interests, to provide research knowledge. In so many jurisdictions, it just doesn't exist, or it's feeble. And I think much less to find an organization akin to the one that Gene's the head of now, or the mass of non-government, not-for-profit think tanks, research groups, advocacy bodies. That infrastructure simply doesn't exist in most countries. I think a possible solution is you need regional cooperation so that you can mass on a regional basis rough equivalents of these, but that is a difficult problem and something that Emma mentioned in who gets to play, I think is very important. I should mention a problem with the ICN is that the decision about who gets to go to the meeting and participate, the government competition agencies play that role. They nominate. You can't get in the room unless you play. And it certainly never was my case, but I'll just suggest that some human beings in these government agencies keep score of whether people praise them or criticize them. And that sometimes serves as a filter who gets in the room. Never me, but I'll just say that some people took that view. So if you don't have some self-nominating process, if the government is the screen, you will end up with puppets who say, great government.
Well, to again provoke you, I'm going to put a suggestion on the table and see how you react to it. If this is a truly big problem for a global norm development and consensus building process, how do we get from here to there? What if we invested in educational hubs around the world in key countries where there is already engagement and interest? There are academics with expertise. There are some NGOs with involvement and interest in the issues. And we try to go build ground up. Basically, it won't happen overnight, but to build up the expertise. Because, for example, as Brazil considers a local hosting requirement for internet servers in response to what they perceive as overexcited surveillance activities from a particular country, there's been a lot of discussion about how it works. Does it work? Can it work? It's technically implausible. But how do you engage with that government? How do you engage with civil society in Brazil to have that discussion in a way similar to what we did with intercarrier compensation or broadband measurement? How do you do that? Is there a path towards that? Olivia, you wanted to jump in maybe on something different?
Well, it's not exactly an answer to your question. I think I do address the question a bit. I just wanted to make a point, and I think it does tie in actually, and that is that I think it is useful for us to distinguish what we might mean when we talk about norms. I think those give us a kind of the evolution of how a norm becomes a law or something binding like law. Between substantive design norms, that is the business of the ICANNs and IETFs of the world, and the multi-stakeholder governance process, which itself, I think, is what is being contested, right? So it isn't, I mean, there are people who think that, maybe that the INF function should be done differently, but I'm not sure that that is the nature of the argument. The nature of the argument is we want to be included, right? And we've been excluded, we want to be included. And so to the extent there's an education that has to happen, it has to be, I think, along the lines of what I think Laura was talking about, and that is an engagement with communities about how to do governance, multi-stakeholder governance.
Other thoughts?
I think you can do it in Brazil, Gene. You have an academic infrastructure there that can support this. With a deliberate effort to go down that path, you could start to replicate the kinds of fora you see elsewhere. It's a harder question if you're saying, what about South Africa? What about, what about China? I mean, if you're looking about, you have in a number of places you have a fairly well advanced academic infrastructure. In others you have a very big academic infrastructure, but it needs a lot of work. In others you have nothing at all, where the regional approach becomes more.
I think it's important to I think it's important to, I think the kind of thing you're talking about, Gene, is essential. Brazil, I think, I agree with Bill, I think Brazil is fully a peer of the United States in being good at multi-stakeholder governance and being good at looking seriously at a lot of these questions from an academic perspective and from a business perspective and from a political perspective. I think that as we look around the world, part of the reason I focus on this particular chart is that I do think we have to take a sectoral approach to these issues. I think that one of the impressions that I hope we can gradually adjust is that there was a view that the world would go to the Internet Governance Forum to answer all Internet policy-related questions. And I frankly don't think that's the right way to suggest we proceed. I think that if there are people who are interested in privacy questions, then there are a variety of venues where that happens. If you're interested in trade questions, there's a variety of venues where that happens. And I think that countries that are feeling left out and are feeling that their interests are not being addressed would be well served to go to either to create new forums specifically for those issues, because they all require specific expertise and to some extent need their own inherent legitimacy in their own networks. But I think we have to start looking at these issues with more nuance and help to build expertise to really make progress on the specific questions.
So I want you to be prepared. We're going to turn to questions, particularly the students. I'm going to give you one final hit here on this. A number of years ago, I brought in fellows from Brazil and Kenya to experience the policymaking process on telecommunications, media, and internet policy issues here. And the one unifying theme from their 6 months here I got back was, while there are tremendous differences, of course, in each culture and how policy is done, they were really emboldened and impressed and energized to look at the opportunities to engage directly with government, to engage directly with the private sector, something that they were not as familiar with in their policymaking process, and engage with the media. And those were universal. And I wonder if there's a way in which that kind of knowledge transfer, exchange programs, building off of some kind of, whatever the educational base would be valuable. And the final thought is that even if Brazil is only one country, and it is only one significant country, it is even more important in the sense that it is a global South leader. And if you're going to have government as a catalyst or government as a leader, at least I'd suggest at this moment, this isn't the moment that the U.S. is best positioned to do that for obvious reasons. And so it's great to have someone from that part of the world stepping up and wondering if we can be doing more to back them up. Any other thoughts from the panelists before we turn to audience? Okay, we got students. Somebody. I'm going to wake you up. Larry Strickling's going to take over. And I'll just say, I'll hand it to Larry. Larry was fully engaged in all these issues and was very active in the discussions at the ITU, and was the leader in the U.S. government with Phil Verveer, asking for meetings with not just U.S. groups and U.S. businesses, but with global civil society organizations and everyone participating in the conference. And it was, again, the feedback that came back. A lot of people have questions about the U.S. government and questions about the companies that reside here, but the universal response that we got from the civil society organizations was they got more information, they got more feedback and input from the U.S. government than from their own governments and their own delegations. And that matters.
So I just wanted to correct what I fear are some misimpressions that have emerged from the discussion. First off, Gene, thank you for the framing. I thought you did a wonderful job of framing the issue, and then Danny knocked us off the rails pretty quickly. But
it's not the first time.
John Nectarline's right that as people have used the term multi-stakeholder, we've applied it to a variety of different contexts, many of them incorrectly. Because I think as we talk about it, particularly in the area of international internet governance, what we're looking for are the hallmarks of participation, ungated participation, where anybody can come. So this idea of people naming themselves gatekeepers is antithetical to a true multi-stakeholder process. And we saw that with our little experiment on the domestic side with the code of conduct, where we said anybody can participate. And we had 400 people the first day. Now that winnowed out over time because not everybody was willing to make the commitment to stick with it. But I think it's important to have that offering at the front end that anybody can participate. And the second part that I think was missing from the discussion was the idea that a true multi-stakeholder process makes a decision. And you're basically that they have taken on either through legitimacy that they bring to it themselves by the virtue of who participates, or in some other fashion, the legitimacy to make the decision that's not subject to review by some other party, which is why I think much of what people were talking about up here were more consultations with stakeholders, but where the regulator or the agency was clearly holding on to that power to ultimately either affirm or reject that decision. And you have to have the ability, particularly in the international context, to be able to accept what that outcome is going to be, I think, in order to really get the engagement you need from stakeholders. Again, to take the example of the privacy codes of conduct, Danny's right. We started with a Bill of Rights that was not developed. It was developed through a consultation. The codes themselves, though, are truly multi-stakeholder in the sense that NTIA is not a regulator. Either this group of people comes together and develops a code or they don't, but it's not as if somebody is going to substitute their judgment on what code is actually developed. So it's a microcosm, I think, of what we're talking about. In the international setting, the best example we've got, and it's not a perfect one, is ICANN in terms of operating where what you have to deal with and what we have struggled with for certainly the last 4 years is the question of how do you define the role of governments in this process. And ICANN, yes, it was created by the United States in the 1990s, but the actual structure under which it operates, I think, was developed in more of a multi-stakeholder fashion, and their governments are just a group of stakeholders. They do not have veto power. They do not ultimately review and say yay or nay to what comes out of it. They have to find a way to participate, and it's been a struggle. Although the way the bylaws are written, governments get kind of a leg up on all other stakeholders because once they opine on a matter, ICANN has to react to their advice in a way that's different than reacting to advice of other stakeholders, but they can reject it. They don't have to accept it. And I think the real challenge that I'm sorry we couldn't have more of a discussion of, which will be reflected in the work this year, is how do governments find their place in this? How do they get to the comfort level where they are willing to be part of the stakeholder body, part of providing input, but don't feel like they have to have the ultimate control over the final decision making? And I think that's the challenge we've got this year. That's the challenge you have when you talk to governments in the developing world about this. And what it requires is having strong constituencies in all of these countries, such as civil society and businesses and technical experts who say, we have something to contribute to this and we want to be able to have input into that final decision making as well.
So is Brazil an opportunity for the U.S. government to carry that vision forward, Larry?
I think it is, but I think, as I said yesterday, what's more important is to be finding other countries, such as Brazil itself, to start carrying that flag forward. And I do think that the way this is played out, particularly as I understand what Brazil's planning, there will be delegations by country, but they're being designed so that governments are a minority in the country's official delegation, but more importantly, there will then be opportunities for anybody to participate wherever they are. I think if they can get to a Cisco telepresence location, they're going to have an opportunity to participate wherever they are worldwide, and I think that's important.
I think that Larry's emphasis on the broad, as he put it, ungated participation model is very important because it is a step in the direction of overcoming suspicions about other decision-making methodologies and approaches that have been used so often that carry with them all the doubts that we've been referring to already. I just want to suggest, Larry, that maybe you you understate the degree to which there has to be some orchestration before that event happens. That is, I don't think you just put a sign outside that says, come on in. You've got to set an agenda. That is a politically sensitive matter. And who gets to participate in setting the agenda? That's often a working group of some kind that has to do that. It's a committee, it's a body. And then when they all come in the room, you have to have some protocol that says who can talk, how long, in what order, can people come back in on issues? These are, as you know, why am I telling you things you already know? I should. They need to hear it. You can end up holding it without making these organizing choices, which again, if they're being made by the usual suspects, are just seen as another manipulated exercise. You can end up holding it in a room that's so big that the curvature of the earth keeps you from seeing the people in the back. And there's a shuttle bus service to bring folks up to the microphone. I just suggest that the ungated participation model understates the extent of organization structure, the filtering choices that themselves usually carry suspicions and concerns about how that's being done, so that, and you can't, to some extent, governments have to be involved in doing that. But I think the intuition that you express about how there is a need for a forum that provides a mechanism to overcome doubts. In this wonderful article that Jean has, the rich guys in Davos sitting down and plotting the future of the universe.
So the article, just so everybody knows, is that this issue came up in Davos. Not in any extensive way, I don't believe. But now there are articles being written that it's the takeover of the multi-stakeholder process by the corporate elite of the world, meeting with a few government officials. So it's a tinderbox. It's such a sensitive issue as to how you create legitimacy for this type of thing.
And my guess is that to answer Larry's last question about how governments feel comfortable about this, until they have some degree of assurance about how this queuing process is going to develop, and maybe there are precursor meetings that take place before they're willing to sit in the room and say, I'm in, and I'll accept the outcome even if it's not my preferred outcome. That's going to take a lot of effort. And I wonder how the legislatures are going to react to this. You delegated your authority to what? They have to be part of the conversation, too.
Did we provoke you, Danny?
So I just want to offer one kind of metric by which we might assess the success and of any given multi-stakeholder process and the degree to which it has the buy-in from whoever we think needs to buy in. And I think it does have to do with the evolution of leadership, as Bill suggests, in these organizations. My observation of technical standards bodies is, they look healthy when what you see is a kind of a group of people who've taken on leadership responsibility, and that group looks a little broader than you might expect it. That people actually have committed, that there's in some sense a community of leaders. Any process anyone ever goes to in the world, people don't participate at equally, but I think you feel just instinctively, humanly comfortable with a process if you see that there's a kind of organic leadership that develops. I think to me that's part of the Brazil challenge is will there be a sense of a broader base of leadership developing, certainly so that it doesn't look like the U.S. pulling the strings, maybe not even like Brazil pulling the strings. I think that my observation of the NTIA process, which all happened after I left government, was that eventually what happened was a core group of people, not government people, and from a diverse collection of interests, kind of took some responsibility for the process and made it happen. And that's when you know you're on the right track.
So we talked about the government side. What I want to
and the final point I want to make is I think that there's an outsized opportunity for civil society to be in that role, because civil society is really unique around the world in that it is not it doesn't have direct economic interest. It doesn't have direct political interest. It's an awfully good surrogate for the set of public interests that matter. And I think there are reasons that civil society organizations worry about lots of these processes, but I actually think and I think you can see this in other fields like the environmental movement, where you have civil society organizations have really an extraordinary leadership role in getting, kind of being the glue that actually makes decisions happen and gets to sustainable agreements.
So I want to pull the private sector into this discussion. So governments can lead, governments can be a catalyst, but governments can't do it all. We need this participation, and you suggest that civil society can play a big role. But what Bill described as the ICN example costs a lot of money to develop the expertise, to have the convenings to do this, and it wasn't all government money. But there's an antitrust bar. There are these functions across companies where everyone knows they're going to have to engage, and I believe they made the decision that they're better off with smart decision makers, well-informed decision makers, and well-informed advocates at the table to have the right debate in the right country at the right moment. So is there a comparable role here for the private sector? We have a global economy. We have companies competing across the world. And I at least hear periodically that they are hampered either by the image of the U.S. or political arguments that create openings to move to domestic manufacturers, domestic suppliers, just as an excuse because they fear the U.S. multinational corporations are possibly working with the U.S. government. Is there a self-interest or an enlightened self-interest here on the private sector side to put more resources into this kind of a function? Anybody? We're getting somewhere. Yes.
Patrick Ryan with Google. I think this is an excellent question, and I want to address first one of the issues that Larry raised that I think is really critical this year is how do you define a role for governments that makes governments feel like that they're actually engaged in this process? It's a really crucial question. One of the things that a lot of people may not now realize is the defining process right now is happening online on this listserv called onenet.org. And if you log into it, you could see, quite a lot of arguments and, sausage being made in a really sort of a crazy way. But this is not primarily governments defining the agenda. And while it's quite chaotic, they're categorizing topics, breaking off themes, and making progress on really hard debates. I'd encourage everybody that isn't familiar with this process to log on to that website, join the listserv, and participate in those conversations. It's a way for everybody to join into the conversation. To your question about the private sector, at Google, this is something we think about a lot. We're troubled by the fact that in order to be effective in this system, we can't be everywhere. It doesn't look good to be everywhere, and if you overfund civil society to participate, then you have this perception of buying civil society, and yet civil society is hampered in their ability to join a lot of these events because they just don't have the funding and bandwidth to join these activities. And even private sector participants like ours depends on a very tight relationship then with governments in order to be able to join. For example, to go to the Wicket, we all received essentially delegation authority as U.S. government delegates to be there. It was a fascinating opportunity, but it's not one that many can take advantage of. So the question I would throw back for the panel here is whether or not this is perhaps becoming itself a discipline. Is this something in our educational world we should start thinking of as governance as a profession? Are there going to be more practitioners of governance as a topic, and how would that how might that develop in the future?
Anybody? I think it's a great question.
Short answer is I think this commands more and more attention of some of the departments where you might expect it would come up: public policy schools, international relations, law schools. The question of I'm willing to bet that half the law schools in the United States probably have a course that sounds something like international governance, and what they're talking about is the intersection of these kinds of issues. So I see seeds of this developing.
So it's you could imagine a profession called being a multi-stakeholderist. But I do think there's this is, I think, partly to Gene's question and yours, Patrick, that I do think there's a unique set of skills. I just look at it from the civil society perspective. There was a time in the United States when the skills that you needed to be a good public interest advocate were either legislative lobbying or litigation. Those were your two venues. That's where you, and maybe in a rare cases, working in regulatory environments. But you were really being in either a kind of a narrow sense a lawyer, or or you were being kind of a sort of a PR sort of driven kind of lobbyist, which is fine and is a necessary set of skills. But this is a different set of skills. Building these kinds of coalitions across lots of different boundaries is and learning to be sensitive about how to talk about issues in ways that are not culturally stupid is a big requirement. And so I think people will have to learn how to do this. Absolutely.
Was there one more question? Do we have the microphone? This is going to be it, the finale, because otherwise I am the only thing standing between you and hearing from the chairman of the FCC.
Thanks. There was one question I guess I had, and Gene asked about sort of the education and outreach function and how do you do that effectively. And it seems to me an organization that has made that a central part of their mission is the Internet Society, and yes, they're not represented on the panel and nobody's mentioned them, but I wondered if anybody had any thoughts on their role in spreading the message and doing that outreach on a global scale.
I think it's a great idea, and I think it's a conversation we ought to have with Kathy Brown. Okay, well, I want to thank you all for your attention and focus. I want to thank our panelists for great presentations. I think we have just a few minutes to rearrange for preparation for the chairman. Thank you.
Thanks, Jim. The deference question is really interesting.
Annual report, you'll see that we talk about boundary jumping. One fun thing about the lunch that people may not appreciate is it's a boundary jumping effort for Hogan Lovells, which in the audience today has partners from Paris, Washington, D.C., and here in Colorado. It is an international firm which has international connections to Silicon Flatirons,